very warm welcome, dear student. Welcome to another keyword revision session with me, CA Preeti Aggarwal. We are revising the entire syllabus of CA Inter, Corporate and Other Laws in a very different format this time. We are highlighting the keywords, the key sentences which are important for exam. They have to be mentioned in your answer if you want to score good marks. If you're watching my video for the first time, I am CA Preeti Aggarwal and I make videos specially for you. Do subscribe to this channel and hit the bell icon so that you get notifications for all the upcoming revision videos. Please visit my website capreetiaggarwal.com for books, lectures, podcasts, test series and a lot of other content. Alright guys, let's get started. In my earlier sessions, I discussed the preliminary chapter, types of companies, procedure for incorporation of company, and we highlighted all the important keywords, sentences, phrases, section numbers. I also discussed with you the parts on which case-based question can be asked and what kind of questions can be asked on the various sections involved in the chapter. So a lot of detailing is covered in these chapters and we try to cover everything at lightning speed so that you can revise the entire syllabus in record time. Alright, so today's session involves discussion on the concept of memorandum and articles of association. This is something which you have already studied in foundation, so I don't think there are many new provisions. Just the part of alteration is included in the CA Inter syllabus. But can questions be asked on the parts which were already tested in foundation? Yes, definitely. It is an important section for exam. Now, what is the meaning of memorandum? Memorandum is the basic document. It is a charter on which the company's edifice is situated. The entire structure of the company is based on this document. The company can enter into only those contracts which are authorized by the memorandum. The company can perform only those acts which are authorized by the memorandum. The object clause of the memorandum basically specifies the work that a company can do. Anything which is beyond the object of the company, of the memorandum will be ultra vires, it will be void, and the company will not be held liable. Okay. So the memorandum and articles, these are the fundamental documents. Let us go on highlighting the keywords. Will a question be asked on the definition or the introduction part of memorandum? I don't think so. But yes, since it is a concept based part, you need to know the definition along with the section number. What in case a very basic question is asked and you need to write the definition. So you need to be aware of the definition and yes, you have to learn it. So according to section 2, clause 56, memorandum means memorandum of the association of the company which was originally framed, that is at the time of incorporation, or it is altered from time to time in pursuance of either this Companies Act or previous company law. So this is originally framed, it means at the time of incorporation, or which is altered from time to time either in pursuance of any previous company law or this act means the 2013 act. So yes, we will memorize the definition. Basically memorandum में लिखा है कि company क्या काम कर सकती है, what is the scope of power, और वो कैसे करना है, what are the rules, regulations, procedures, restrictions, all that is mentioned in the articles. Memorandum is the charter, so let us go on highlighting the keywords. It is the charter. It defines the constitution and the scope of powers of the company. These are the businesses which the company can conduct. The company can perform only those contracts which are authorized by the object clause of the memorandum. Any act beyond that will be considered as ultra vires and void. It will not be binding on the company. The memorandum is a public document. This is what creates a lot of problem because anyone who is dealing with a company is presumed to have knowledge of the memorandum and articles. Not only knowledge, but he is also presumed to have understood the contents of the memorandum. Now, if you are entering into contract with a company, it is your duty to check whether the contract can be entered by the company or not, whether it is authorized by the object clause or not. Authorized, or I should say covered by the object clause or not. So the burden of checking lies on the third party. And why does that lie on the third party? Because these memorandum and articles, whenever they are filed with the ROC, they become public document. You can visit the website of MCA, pay 100 rupees and inspect the memorandum and articles of any company. So because these are public documents, they are available in the public domain, you are supposed to have knowledge of the memorandum. It's a negative doctrine, yes, and you are already aware that this is covered in the doctrine of constructive notice. Every person entering into contract with the company is presumed to have knowledge. You are presumed to know about the contents of the memorandum. This kind of presumed knowledge is known as the doctrine of constructive notice. Okay, it is known as the doctrine of constructive notice. Anyone who is dealing with the company is presumed to have knowledge. We assume that you already know about the contents of the memorandum and articles. It's a negative doctrine. Yes, it's a negative doctrine. It is against the outsiders. It is favoring the company. Any act which is beyond the powers given in the memorandum is ultra vires. It is hence void. So these are my keywords. In case a question is asked on the basic points, basic introduction of the memorandum and articles, this is what you need to know. Do I need to memorize section 399? Yes, it is important for exam. You need to know section 399, that after the documents are filed, they become public documents. Okay. What is the purpose of memorandum? It has two purposes: object oriented and risk oriented. So let me write over here, this is risk oriented and object oriented. The memorandum helps the intending shareholders to know where and how much risk they are undertaking by investing in the company. So it is important for shareholders, intending shareholders, the ones who are going to invest. They want to know where my money is going to be invested, where my money is going to be utilized by the company, in which areas. Each area has its own risk. So what is the risk that I'm undertaking by investing in the company? It enables the person dealing with the company, the outsiders. Okay, it helps the outsiders to know whether the contracts that they want to enter is within the object clause of the company or not. So it also helps the outsider to know the objects of the company. So it is object oriented. What are the contents of memorandum? Yes, a question can be asked on the contents. Here you are expected to explain the contents in brief. You need not write the entire theory, or they may ask you a question on the name clause, specifically on any particular clause. Now we have the name clause, the registered office clause, object clause, capital clause, liability clause. There are many clauses. Let us discuss them one by one. So the name clause. Now this is something which every company will have in its memorandum, because the first thing that the company does is decide upon the name of the company. In the previous session, we discussed that the name application is made in Spice Plus Part A. These are the new forms, integrated forms for incorporation of the company. So if you are applying first for the name, you can apply for two names. If you are filling the Part A and Part B, that is incorporation form together, then you have the option of just applying for one name of the company. So you can apply for the name of the company. The name of a private company must end with the words private limited, public company will end with the words limited, and OPC will end with the words OPC private limited. But there is one company which need not add the word limited or private limited to the name. Section 8 company. Even government companies, they have this privilege of not adding the words limited or private limited to the name, but provided they have filed the financial statements under section 137 and annual return under section 89 with ROC. So yes, the name of a private company will end with the words private limited, public company will end with the words limited. Section 8 company, let us highlight. Section 8 company, that is a non-profit organization, they can without writing the words limited or private limited in the name, incorporate the company. Their names will contain words like foundation, council, federation, trust, etc. Okay, so those words, they are allowed only in case of section 8 company. Government company, yes, you can also claim exemption from writing the suffix limited or private limited, provided you have filed the financial statements and annual returns properly with ROC. Okay, the names should not be against the emblems and names Prevention of Improper Use Act 1950. This is something which you have to write in your answer, so it is a keyword. The name which is mentioned in the memorandum shall. All right, I have a small table for you. These are important rules and you need to memorize them. Rule 8 says that the name of the company should not resemble the name of an existing company. So let's say, for example, that the name of an existing company is JK Industries Limited. I cannot have words like J.K Industries Limited. That will not make the word a name, a different name. It is resembling the name. You will not, ROC will not grant this name to you. I write J.K Industries Limited. This is not something which is different from the name of an existing company. You will not be allowed to register the company with this name. So I have J.K. I'm trying to make the company different because I want the same name for my company. This will not make the company name different from the name of an existing company. It is resembling the name of an existing company. You will not be allowed to register a company in this name. Rule 8A says that the name should not be undesirable in the name in the opinion of the central government. Undesirable means it should not hurt religious social sentiments. It should not be prevented under the Emblems and Names Prevention of Improper Use Act. What if your name contains an already registered trademark? Like say for example, Tupperware is an already registered trademark. Okay, Tupperware is an already registered trademark. R means it is registered trademark. I like this name, so what I do is I include the name Tupperware in the name of my company in this manner. Now, in this case, ROC says that it is resembling the already registered trademark of a company. You will not be allowed to register the name containing a registered trademark. You will not be allowed to register a name which contains words which are offensive to a particular section. Like you cannot use the word Dalit. You cannot use the words which are specific to any political or a religious sentiment can be heard. We will not allow you to be registered in a name containing those words. There are certain words or expressions, if you want to use them, then you need to obtain a prior consent of the central government. So words such as board, commission, authority, undertaking, national, union, these are few words. If you want to include them in your name, then you need to obtain the approval of the you need a prior approval of the central government. So this is a small chart which I have prepared for you. The provisions are mentioned here, and let us highlight the keywords. Rule 8 says that it should not be identical. It should not resemble too nearly the name of an existing company. So these are words and you have to write it in this manner only. Rule 8A says that it should not be undesirable. You also have to write in the opinion of the central government. Rule 8B says that if there are certain words or combination of those words, if you want to use them in your name, then you need the previous approval. Okay, previous is important. You need the prior approval of the central government. Okay, so board, commission, authority, undertaking, national, if you want to use these words, you need prior approval of the central government. If the proposed name includes words like insurance, bank, stock exchange, venture capital, asset management, nidhi, mutual funds, etc., a declaration shall be submitted while applying for the name, that the requirements mandated by the regulators, like in case of insurance, the mandate of IRDA, banking, RBI, stock exchange, SEBI, we have also complied with their guidelines as to the name of the company. So that declaration will also be filed along with the name application. Cancelling of name is important for short note. Yes, it can be asked as a short note. Now, what are the keywords in this? If after reservation of name, the after word is important over here. When did I come to know about something wrong in the company? What if the name was obtained by some fraudulent means? I came to know about this after the name was reserved. Now, how is the name reserved? In case of a new company, okay, in case of a new company, the name is reserved. Let me write it in case of a new company, the name is reserved by filling spice plus part A. Okay, so if after the reservation it is found that the company has applied for the name by furnishing, this is keyword for us, furnishing wrong or incorrect information. If the company has not been incorporated, again we will highlight this with some other color. If the company has not been incorporated, now in this case the company had first applied for the name in Spice Plus Part A. The name was approved. Okay, so in this case the name was approved. See, it is after the name reservation we found that the company is now registered with a name. Okay, they have applied for a name. The name was applied. The company is not yet incorporated, but the name was applied by furnishing wrong or incorrect information. Now the company has not been incorporated. It means that part B may have been filled, it may not have been filled, but the company is not yet incorporated. ROC has not issued the certificate of incorporation, and we find that the name was applied by furnishing wrong information. Now what is an example for that? I mentioned that Savaria is my registered trademark, and I applied for the name containing that registered trademark. Later on it was found that it is not my registered trademark. So if later we found that the company was furnished by providing wrong or incorrect information, the company has not yet been incorporated, then what is the first step? Let us highlight the first step. The reserved name shall be cancelled. This is step number 1. And the person who has made the application will be fined to penalty which may extend to, that is maximum penalty of rupees 1 lakh. The person will be liable, not the company liable, because the company has not been incorporated. We cannot hold the directors liable because now we don't have directors as the company is not incorporated. So any person who is who has made that application can be held liable. But what if the company has been incorporated? Then the registrar, after giving the company an opportunity of being heard, that why did you apply for the name containing wrong or incorrect information, if the company has been incorporated, then the first step is that we will either direct the company to change the name within a period of 3 months after passing an ordinary resolution. So these are keywords. Change your name within what time? 3 months. How? By passing just an ordinary resolution. By simple majority you can change the name of the company. If the company is not ready to do so, then we will pass an order for striking off the name of the company, or you can also make a petition for winding up of the company. See, striking off is a milder version of winding up. It is generally for companies that have less liability, or they can be wound up very quickly. So this is an alternate solution, either strike off or wind up. So this can be asked as a short note. It is important for us. The second clause is the registered office clause, that is section 12. Now every company must within 30 days of incorporation have a registered office, and it should be a registered office, and it should always have a registered office till the winding up. Doesn't mean that you have to remain at the same place. You can shift from one place to another, but the concept of registered office should always be present in case of a company. Now what is the use of this registered office? This is given in the answer itself. Why will a company, why is it necessary, why is it mandatory for the company to have a registered office? See, there are various uses of the registered office. It is basically a place where communication takes place. You cannot just provide a post office or post box address like this is the anyways, nobody sits at my registered office. My head office, corporate office can be different. It can be at a separate place. So nobody sits at the registered office. I don't need a registered office. See, basically registered office is a place where communication takes place. So what I do is I take a post office box and I tell them that whatever communication you want to send, you send it over there. That is not allowed. That post office box address is not allowed. Your registered office means a physical place where a person is always available to receive or send documents. Okay, sometimes we want to send you notices. We want to, ROC wants to send communication. We want to serve a notice. Okay, we want to serve summons to you or serve a legal notice. So we need some physical place at least. We need somebody to sit there. So it has to be a physical address, not a post box number, post box address. So it is a place for serving and receiving the document. So this is the first use. It establishes the domicile. It establishes the nationality of the company. It is important for determining the jurisdiction, like the courts which are applicable. So if my registered office is, let's say for example, my registered office is in the state of Maharashtra, it is in Mumbai. So wherever my registered office is situated, the court's jurisdiction will be determined on the basis of my registered office. This is also a place where communications are sent, notices are sent, etc. So I must have a registered office within 30 days of incorporation, and I must also send to the ROC a verification of the registered office. So that is also another keyword. The verification will also be submitted. Now what is included in verification? Like my light bill, water bill, telephone bill, rent paid receipt, ownership documents, that must also be sent. It is a proof that yes, this is actually the registered office of the company. All this will be sent in INC 22. INC 22 is basically filed to inform the ROC about the location, and it is also filed in case of change of registered address. So that is a form which informs the ROC about the exact address. My memorandum only, I need to mention only name of the state. The exact address need not be mentioned. That can be separately communicated to the ROC. This is because if I write the exact address and I shift from one place to another, I will have to alter the memorandum again and again. Here in this case, if I write only name of the state, and I will have to alter the memorandum only when the state is changed, it is altered. Okay, so memorandum will only mention name of the state. Exact address is not required. That can be communicated to the ROC. Publication of name and address. See, wherever my name is mentioned, I also have to write the registered office address. So in case of letterheads, bill paper, invoices, outside my registered office, wherever the name is printed, wherever the name of the company is mentioned, I also have to write the name of the registered office. And yes, there are other requirements also, like in the letterhead you will also have to include the website of the company, the mobile number, etc. So all those are other requirements. The name and address of the registered office must be painted outside the office, or it must be affixed outside every office. Like you can have a board, you can paint it, and it must also be mentioned in one of the languages, that is local regional language. So if you're in Maharashtra, it should also be mentioned in Marathi. If you're in some north country, then you can north state, then it will also be mentioned in Hindi. It must be engraved and legible, means clear characters on the seal. The corporate identity number SIN will also be mentioned along with the telephone number, fax, email, website on all billhead, letterhead, paper, other official publication. It should be printed on the bills of exchange, promissory, hundis. This is important for short note questions have been asked on publication of name and address. That is why it is important for us to include all these terms in our answer. If the company has changed its name, this is important for MCQ. If the company has changed its name in the last 2 years, then what was my former name? That must also be mentioned along with the new name. For another 2 years, I will mention that. OPC will write the words OPC Private Limited in the name, and in case of every change, I will also inform the ROC within 30 days of change, again in INC 22. So this is a common form which is filed for notice of situation of the registered office and also the change of registered office. Then we have the object clause. Object is the purpose for which the contract, for which the company is incorporated. The object will include the main objects of the company as well as the other or ancillary objects of the company. These other objects are required to fulfill the main objects of the company. The company can enter into only those contracts which are authorized by the memorandum. Anything beyond the object clause will be considered ultra vires and void. The company will not be liable. Then who will be liable? You can hold the officers, the directors who are entering into that contract personally liable. In this case, we can say that the corporate veil is lifted. Corporate veil is lifted for ultra vires transactions. So any act which is beyond the powers given in the memorandum will be ultra vires and void. It is very important for us to note that if the act is ultra vires, the memorandum, it cannot be ratified, it cannot be confirmed even if we obtain the consent of each and every member. It cannot be ratified even with the unanimous consent of each and every member. Yes, if the act is ultra vires the articles, it's an internal document that can be ratified, but you cannot ratify a contract which is ultra vires the memorandum. Okay, the company will not be liable for acts which are ultra vires. Now, what kind of question is asked on the ultra vires on ultra vires? A short note can be asked on the doctrine of ultra vires. You have to compulsorily mention the name of the case law. If you can memorize the provisions of the case law, nothing like it. Okay, so yes, if a question is asked on ultra vires, you have to write these provisions. Okay, you have to explain ultra vires, you have to write the name of the case law also. Ashbury Railway Carriage and Iron Company Limited versus Ritchie. Now, what was mentioned in the case law? What are the facts? Let us go through the facts in this arrow format. The company was authorized by its memorandum to make, sell, lend on hire railway carriages. That was mentioned in clause 3. And they also mentioned in clause 4 that anything beyond this, beyond clause 3, can be possible. You can do it only by passing a special resolution. Now, the company agreed to give Ritchie and his brother loan for building railway in Belgium, like laying the lines, the overhead wires, platform, etc. Now, was the company authorized to give loan for this purpose? No, the company was only authorized to make, sell, lend on hire railway carriages and wagons. It was not authorized to give loan for building railways. Okay, was a special resolution passed authorizing this? No, a special resolution was not passed. In this case, the company refused to perform this contract, saying that it is an ultra vires transaction. Ritchie said, but you have promised you will have to perform it. They filed a case. What do you think? Would they have won the case or lost the case? They would have lost the case because it is not authorized by clause 3 and it is also not authorized by a special resolution. So the company cannot be held liable. The company cannot be forced to perform this contract. It is the ultra vires, the memorandum. So in case of ultra vires, do we need to memorize the impact? Yes, a question is asked on the impact also. So if the act is ultra vires the memorandum, then the company cannot be liable. Okay, it is ultra vires the company. It is void ab initio. It cannot be ratified even with the unanimous consent of each and every member. The company cannot sue. The company cannot be sued because this act is not binding upon the company. You cannot file a case against the company. But yes, the directors, the officers, they can be held personally liable. In this case, we can say that the corporate veil is lifted. Okay, it is lifted. What about contracts which are ultra vires? The articles that can be ratified because they are internal documents. You can alter the articles, you can bind the members, you can bind the company for those contracts. But for the acts which are ultra vires, the memorandum, it cannot be ratified even if you obtain the consent of each and every member. Liability clause will mention whether the liability of the members is limited or unlimited. See, we are always discussing liability of the member. We are not discussing liability of the company because the liability of the company is always unlimited. It is the member's liability which we are discussing through the memorandum, whether it is limited or unlimited. Then we have the capital clause. This will always mention the authorized capital, details of the authorized capital. So authorized capital of the company is rupees 5 lakh divided into 50,000 shares of rupees 10 each. Only that information will be given in the memorandum. Anything other than that will be mentioned in the articles. I can alter the capital clause. I want to issue more shares. I want to increase the authorized capital. I can do that. Yes, you will have to pay the remaining stamp duty, the difference of the stamp duty. I can also reduce this. Whether you will get a refund, yes, you are entitled, but taking money from the government, so you can imagine how difficult that can be. Association clause. Now, in the memorandum, you will find a table in which the subscribers have mentioned their name, their address, etc., and the number of shares which they have agreed to subscribe. Okay, so this is known as the association clause. They have agreed to purchase the number of shares mentioned against their name. In the previous session, we had discussed that this money which they have agreed must be brought in the company within 180 days, and a declaration will have to be given in form 20A. Name of nominee will be mentioned in case of OPC. Now, this clause is the succession clause. It is mentioned only and only in case of OPC. It is not required to be mentioned in case of any other company. Form of memorandum. This provides the model memorandum of the company. Yes, model memorandum. You can either follow this as it is, or you can have your own memorandum, or you can use a combination. So this is model. You can memorize this. Now let us discuss about alteration. This is very important for exam. The first few steps in my notes, these are the steps. This talks about voluntary, okay? This talks about voluntary name change. And point 6 discusses compulsory name change. So if a question is asked on name change, if the company is doing it voluntarily, then you will follow the first 6 steps. And if it is compulsory name change, then the 6th point is to be mentioned. Okay, all right. The section number in case of compulsory name change is very important for exam. It is very frequently asked in the exam. Now, first let us discuss about voluntary name change. Who will recognize the need for name change? Who will feel that yes, we need to alter the name of the company? It will be decided by the board of directors. So they are the persons who will recognize the need. They will first consider the need for changing the name of the company. See, we have maybe changed the objects of the company. We have expanded. So in order to reflect the objects in the name, we want to alter the name. There is merger. We are better known by our abbreviated version. There are so many reasons for altering the name clause. So the board of directors will first realize that yes, we need to alter the name of the company. Then what will they do? They will call a board meeting. They will pass a board resolution. What will be mentioned in the board resolution? Will they directly alter the name? No. In the board resolution, they will agree that yes, we need to alter the name. We need to call the members. So that board resolution will be called to hold the general meeting. Then they will hold the general meeting. The company will buy special resolution. So this is the key word. We need to pass a special resolution. They will pass a special resolution, and you also need the approval of the central government. However, the authority is now delegated to ROC. Specified in writing, they will then change the name. Why do we need the approval of the central government? See, sometimes you have incorporated a Section 8 company. The name does not include the words limited or private limited. That is a privilege given. Then you now alter the objects of the company. You are now a profit-making company. You want to include those words in the company. You want to change the name of the company. So in this case, you need the approval of the central government. Also, what if earlier your name was unique, But now you are very smart. You want to change the name, which is now resembling the name of an existing company. You feel that now nobody is going to check. ROC has already incorporated your company. How will they know that we have changed the name? So we say nothing doing. We don't want you to mess up with the name. We don't want your name to be resembling the name of an existing company. So in this case, you need to obtain the approval of the central government. You need to keep them in loop so that they check whether your name is still unique or not even after changing. But the approval of central government is not required when the only change is either adding or removing the word private from your name. That happens in case of converting a private company to public, public to private. If that is the only change, you're not changing the main words of the company, then you need not obtain the approval of the central government. So we will apply for the approval, only then the name change will be considered final. This special resolution and the approval will be filed with ROC, that goes without saying. Special resolution is generally filed in MGT 14 within 30 days of passing the resolution. So within 30 days you have to file it with the ROC. Change of name will not be allowed. This is important for case-based questions. Okay, the change of name will not be allowed if the company has not filed the annual returns or financial statement, or it has failed in repaying the matured deposits, debentures, interest, along with interest. So if there is any kind of obligation, we will not allow you to avoid that obligation by changing the name of the company. So this is important for case-based question. Okay. Once the name change is approved by the ROC, then he will enter the new name in the register of companies and they will issue a new certificate of incorporation with the new name, and the change will be final when you receive that certificate. So these are the procedures, steps to be followed for voluntary name change. Voluntary name change is discussed under section 13. See, alteration of memorandum is basically section 13. It is to be read with the relevant rules. But compulsory name change is discussed under section 16. See, we try that your name should not resemble the name of an existing company, but unintentionally, not deliberately, through inadvertence. Inadvertence means it is not deliberate, it was by mistake. If the name is now resembling the name of an existing company and the existing company has approached you for name change, you refuse to voluntarily change the name of the company, then that existing company can go to the central government. So when an existing company approaches the central government and explains that you have registered a company which is using a name which is similar to my name, then the central government will order the newly registered company to alter the name. See, the name will be kept by the existing company only. The new company will have to alter the name. And if the central government has sent a direction, then we will have to compulsorily comply with that and alter the name of the company within 3 months by passing just an ordinary resolution. So if in the opinion of the central government, yes, the name is identical or it resembles the name of an existing company, then they will give you a direction and you will have to, by passing just an ordinary resolution, important for case-based question as well as MCQ questions. By an ordinary resolution, again, if you're changing the name, you have to obtain the approval of the central government. You will have to alter the name within 3 months from receiving the direction. Okay, if the owner of a registered trademark, okay, now I am changing over here, I am the owner of a registered trademark, okay, I find that there is another company which is using my trademark, they are not altering the name voluntarily, we can approach the central government will ask the newly registered company to alter the name because you are using the trademark of an already registered company, and in that case the new company will again passing an ordinary resolution within 3 months, same color codes, ordinary resolution, 3 months, the company will then change the name. Now this is by the owner of a registered trademark, but the application has to be made within 3 years of incorporation. Now, how will I know that some other company is using my registered trademark? See, you keep checking every year to ensure that your trademark is not being utilized by some company. So while checking every year, you came to know that somebody is using your registered trademark, make an application to the central government, but do that within 3 years. Because after 3 years, even the newly registered company will start having its own goodwill, then it will be difficult for us to change the name. Okay, now when the company obtains this new name, you have complied with the requirements of the central government. Have you communicated this to the ROC? No, inform him also. So within 15 days, again important for MCQ. So within 15 days from the date of change, we will give a notice of change to the ROC along with the order of the central government. Now in this case, central government, wherever the word is used, it is replaced by the regional director. That power is delegated to the regional director. the new the ROC will then give you a fresh certificate of incorporation, and then your name change will be effective. What if I don't comply with the instructions of the central government? I'm a very stubborn person, I don't want to comply with this direction of the central government. Then instead of giving penalty, earlier it was penalty, now what the central government does, they will allot you a new name, and it is a very what should I say, a bad combination of name that they will give you. It starts with ORDNC. Okay, these letters will be mentioned in the name of a company. What does this mean? Order of regional director not complied. Why regional director? Because I explained, in case of central government, the authority is delegated to the regional director. This will be followed by the date of the year of direction. Okay, this will be followed by the year of direction. This is the year in which the central government had issued a direction to you to change the name and you have not complied with, followed by the serial number of the company, followed by the corporate identification number. This will be the entire name of the company. I don't like this name, go and voluntarily change the name by following the procedure of section 13. So indirectly I have compelled the company to follow the directions of the central government. So I think this was a very smart move. Okay, next we have alteration of the registered office. Now please note that because only the state is mentioned, only when you change the state, your memorandum will be altered. In other cases, memorandum will not be altered. So in case of change of state, section 13 will apply, because that is the section for alteration of memorandum. In other cases, section 12 will prescribe the procedure for altering the registered office. Only when state is changed, section 13 will apply. That is alteration of the memorandum. Now, if you're moving from one premise to another, one building to another, one place to another, same locality, same city, don't trouble the shareholders. This is possible through a board resolution. So this is my keyword, board resolution. But inform the ROC. So INC 22 needs to be filed. This is a common form for informing him about the location as well as change of location. So we will file INC 22 with ROC within 30 days of change. Okay. Notice in INC 22. But if you're shifting from one place to the other, one city to the other, okay, you're changing the city, one city, town, village to another, but in the same jurisdiction of ROC, now you will approach the shareholders, you will pass a special resolution, and the next sentence will be a copy of the special resolution will be filed with ROC in MGT 14. Location of new address will be given in INC 22. If you're moving from the jurisdiction of one ROC to the other ROC, but within the same state, now generally one state, one ROC, but there are two states in India. One is Maharashtra and other is Tamil Nadu. Yes, let's highlight. In Maharashtra, you have, I'll use the same color. In Maharashtra, you have registered office. Sorry, you have the ROC in Mumbai and Pune, and in Tamil Nadu, you have it in Chennai and Coimbatore. So if you're moving from one ROC to the other ROC, okay, from jurisdiction of one ROC to the other ROC, then there is a separate procedure which you need to follow. Here the regional director will come into picture. See, there are 4 regional directors in our country. They have ROCs under them. So if you're moving from one ROC to the other ROC, you need to make an application to the regional director, inform him, he will also give his consent, and after that you will proceed to the ROC. A special resolution. So step number 1 is a special resolution is required to be passed, and a copy will be filed with ROC within 30 days in form MGT 14. The company will have to first obtain the approval of the regional director. So make an application to the regional director. The regional director will give the confirmation within 30 days. So 30, 60, 30. This is how you will remember. 30 days, regional director will give the approval. Okay, so regional director will communicate his confirmation within 30 days. These are the keywords. I'm underlining the keywords. Then this copy of the confirmation that yes, listen, ROC, we have obtained the approval of the regional director, that will be filed with ROC within 60 days. So 30, 60, 30 days may ROC, okay, ROC will be required to register the same and certify the registration within 30 days from the date of filing the document. So 30, 60, 30. I have highlighted the keywords. You can pause the video. You can highlight them in your textbook. If you want, you can purchase this textbook from my website, capreetiaggarwal.com, and highlight the keywords, highlight the steps, make notes along with me. Now you're shifting from one state to the other state. Okay, then memorandum will be altered. What are the steps? The first step is pass a special resolution, seek the approval of the members. After the members approve, then we will go to the central government, and the central government will dispose the application within 60 days. So here it is 60/30. Okay. So after the members approve, then we will apply to the central government that we are shifting from one state to the other. They will give their approval within 60 days. Have you also consulted your debenture holders, other persons whose interests are likely to be affected, like your creditors, your debenture holders, your customers? Have you also informed them that we are shifting from one place to another? See, you owe money to them, so you have to also obtain their consent. The company is also required to give an advertisement in the newspaper. Now, why? See, we are giving a notice to these people, but what if they claim that we have not received the notice? Then everybody reads the newspaper. Give one notice in the newspaper, one English, one vernacular newspaper. Either you obtain their consent, or you settle their claim, or give them some security. Okay, so the dissenting shareholders either obtain their consent. So what is step number 1? Let us highlight. Either obtain their consent, or their claim or debt must be discharged or secured. Okay, so either obtain their consent, or you discharge, means return their money, or you can also give them some security. After you have obtained their consent, go to the ROC, file the necessary documents to registrar within 30 days. So what was the key over here? 60/30. In the earlier case, it was 30/60/30. Now, where we are going, that registrar will give us a fresh certificate of incorporation, enter in the register of members. After that, my registration is complete, my shifting is complete. So they will issue a fresh certificate of incorporation. Next is alteration of the object clause. Now, I have obtained money by issuing a prospectus. I had informed the members that I am going to use your money for construction of, let's say, for example, commercial property. Okay, I am going to use it for commercial property. This was the object mentioned when I had raised money from the public through the prospectus. I had raised, let's say, 100 crore rupees. From this, I utilized 40 crore rupees in construction of the commercial property. But after COVID, I realized that people are not buying offices. They prefer working from home. Instead, they are buying new and bigger homes, because offices have also realized that it is not required to come to the office. Work can be done from home also. So the remaining 60 crores I am now planning to utilize for developing housing property. Now, this is not the purpose for which I had raised money. I cannot cheat the members. I need to inform them that, look, I am altering the object clause. I am now planning to utilize the remaining money in housing project. If you are ready, then we will go ahead with it. If you're not ready, then you can take back your money. We will give you an exit. Okay, so in this case, you need to inform them the money received, how much you have spent on commercial, how much you are planning to spend on the housing. Are you planning to spend the entire amount or only some part on housing? Give us the reasons. Where is the place where we can go through all these documents? So if the company has raised the money by issuing a prospectus, but it still has some unutilized money, then you have to pass a special resolution. That is the first and the primary step. Okay, special resolution, and that too through postal ballot has to be passed. You're changing the objects of the company. First, we will give a notice. See, if you want to pass a special resolution, you will have to call a meeting. In order to call a meeting, you will have to give a notice. In the notice of the meeting, you will mention the amount received. In my example, 100 crores. So we will mention that we have received 100 crores. Out of that, what is the amount that you have utilized? In my example, we have utilized 40 crores. What is unutilized? That is 60 crores. Why are you changing the objects? How much you are planning to utilize for the new object? Is it the entire 60 crore you are planning to utilize, or only 40 crores you are utilizing? How much are you planning to utilize for that? Where can we see the copy of the notice and other relevant information? This resolution will also be published in the newspaper, because there are people who say that we did not receive the notice, we could not attend the meeting, you passed a resolution without us, that resolution is not valid. We don't want people to object, so we will also give a notice in the newspaper, one English, one vernacular newspaper, having wider circulation. And it will also be placed on the website of the company. You either obtain their consent, but if they don't give their consent, then you can't force them. So in that case, the dissenting shareholders will be given an opportunity of exiting. All right, we will also file a copy with ROC. Special resolution hai, that is why we have to file it with ROC, and he will certify within 30 days of resolution. Alteration of capital clause, section 61, we will discuss that later. Here they are talking about alteration of the authorized capital, because that is the clause, that is the capital which the clause discusses. It is possible when I want to issue more shares. Next, we have the concept of articles of association. Okay. Now, articles, they are the bylaws of the company, they are the internal regulations of the company, they are the procedures, restrictions, everything is mentioned in the article. See, company is an artificial person. So, we need to inform the company what work it can do, how it can do, and that is informed to the company through the memorandum and articles of association. So section 2 clause 5 defines it. We have already covered this previously. Now let us go on highlighting the keywords. If a question is asked on articles, what are the keywords that you should mention in the answer? So articles, they are, you will highlight rules and regulations. This has to be mentioned in your answer. Rules and regulations. They are framed to manage the internal affairs. So framed to manage the internal affairs. You will notice that the words are repeated. Internal regulation, internal rules and regulations. It is the fundamental condition. Okay, that is important. Again, we have internal regulations. They are internal management of the company. They are the bylaws of the company. Okay. Articles can be, now let us change. They can be in schedule 1. These are the model articles. You can also frame your own articles. You can use a combination. If nothing is specified, ROC will apply the model articles to you. So if you don't have your own articles, we will apply the model articles. If in your article something is missing, even then in that case, the model article provisions will apply. Okay. Entrenchment is very important for short note. I had done a separate video also on this. You can watch that video. Now, if I want to make the articles more protective, more strict, then that is known as entrenchment. Let's discuss it with the help of an example. Mr. Tarun, he started a business as a private company. It was a very close-knit family business. Okay, he incorporated a private limited company. Initially, he and his family, they were holding all the shares of the company. But in the and in the articles also, he mentioned that he will be the director for life. Okay, he will remain director for life. But he fears that if tomorrow non-family members take control of the company, they own more than 75% of the voting power, they will remove him from the position of the director. He doesn't want to do that. So he has mentioned in the articles that if 95% of the members vote against me, only then I can be removed from the position of the director. So instead of 75, he has mentioned that only if 95% vote in my removal, only then I can be removed. It means the articles are entrenched. Okay, so here instead of 75, you're increasing it to 95. You're making the articles more protective. This is nothing but entrenchment. See, entrenchment can be added anytime, at the time of incorporation or later also. Okay, they can be at the time of formation of the company. So in your incorporation document, it will be mentioned that whether your articles are entrenched or not. Later, by amendment, you can add in by amending the articles. But in case of private company, let us highlight that also. In case of private company, you require consent of all the members, and in case of public company, you require just a special resolution. Notice of this entrenchment will be given to ROC. Okay, so different colors are used so that the points are highlighted. This is important for short note. This is important for case-based question. Okay. Then we have the form of articles, alteration. It is very simple. Alteration is possible by passing just a special resolution. Okay, that is important for us. Binding effect of memorandum and articles. See, the memorandum and articles, they bind only the company and members. It is a contract. Okay, articles, memorandum, it is a contract between members and company. So company is liable to members, members are liable to company. It is not a contract with outsiders. Outsiders are in fact stranger to contract. So anything which mentions any benefit, any right to outsider, if it is mentioned in the articles, that cannot be enforced by the outsiders, because memorandum and articles, they are binding only the members and the company to each other. So memorandum and articles, when they are registered, it is as if later on, even if you purchase the shares of the company, it is like you have signed the memorandum. We assume that you have signed it. It is signed by the company and each member. Even at the time of incorporation, not every member signs it, but if the subscribers have signed it, it is as if the members have only signed. If you are purchasing the shares of the company, we assume that you have read the memorandum, you have read the articles, you have agreed. It is as if you have signed them. Therefore, company is liable to members. Members are liable to the company. But members are not liable to each other because it is not a contract between member. It is a contract between company and member. So if the rights of the member are not complied with, okay, if the company is not protecting the rights of the members, they are not allowing the members to exercise their rights, members can file case against the company. Okay, the company can also file case against the member for, let's say, recovery of call money. The term outsider, it is defined as a person who is not a member. It may be that he's a director of the company, but he's not a member. Solicitor, he's not a member. It does not constitute a contract between the company and outsider. So if something is mentioned in the articles, like say for example, that we will appoint A as the solicitor of the company, this was mentioned in the articles of a public company, but we appointed Mr. B. Can A enforce this contract? Can he say, my name is mentioned, I have to be appointed as a solicitor? But there is no contract between the company and Mr. A. Just because your name is mentioned in the articles doesn't mean that you will be appointed as the solicitor. You cannot even file a case against the company because the memorandum and articles, they are binding the company and the members. They are not binding the outsiders. But what if I had a separate contract with the outsider where I had mentioned that pursuant to this contract, you will be appointed as a solicitor? Then can the outsider file a case? Yes, on the basis of that contract, but not on the basis of the articles. What if Mr. A was a member? As a member, can he file a case? No, not even then. Even in that case, he cannot file a case. Why? Because his right of a member is not affected. Being appointed as a solicitor is not your right as a member. You can file a case only if the right of a member is affected. Okay, so in this case, even if he is a member, he cannot file a case. The doctrine of constructive notice, you had already studied this last time. Knowledge, okay, knowledge can be either expressed or implied. Implied means it is presumed. Expressed or actual. Expressed means I'm actually coming and telling it to you. Implied, we are assuming that you're already aware of this. The doctrine of constructive notice is implied or presumed knowledge. We assume that if you are entering into contract with a company, you have already gone through the memorandum. If you're purchasing the shares of the company, you've already gone through the memorandum. This presumed knowledge is known as a doctrine of constructive notice. It is a negative doctrine. Because if the outsider enters into a contract which is beyond the objects of the memorandum, outsider will have to blame himself for his ignorance. He cannot say that I did not read the memorandum and articles. It is a public document. It is available in public domain. You are supposed to read the document before entering into contract. That is the doctrine of constructive knowledge. Let us quickly go on highlighting the keywords. Every person is presumed to have knowledge of the contents. Why? Because they are registered with the ROC. They become public documents. They are open for inspection. Section 399. Everyone dealing with the company is presumed to have knowledge and also understood them. This is the doctrine of constructive notice. So if you are entering into contract which is ultra biased the company, then you will have to do it at your own peril, at your own risk. It is a negative doctrine. It is against the person and not against the company. There is, yes, I agree, there is an exception to the doctrine of constructive notice, and that exception is the doctrine of indoor management. See, we are expected to have knowledge of the memorandum and articles, but we cannot be expected to know whether the procedures which are mentioned by the company are actually being followed by the company or not. These internal procedures, they are happening behind doors closed to us. So you cannot blame the outsider for internal irregularities of the company. The key word over here is irregularity. Okay, the key word over here is irregularity. You can assume that if the procedure is mentioned, then that must have been followed by the company. This is the doctrine of indoor management, but they have also introduced exception to these doctrines. Knowledge of irregularity, suspicion and forgery. If you had knowledge of irregularity, how did I have knowledge? Because you yourself were a party to that transaction. You were present over there. Like say for example, directors will never get the benefit of indoor management. Now directors knew that the memorandum, although it allowed the company to borrow, articles had imposed restrictions that the company could borrow only £10,000 without the approval of the company. Anything beyond that required the approval of the shareholders or members in the general meeting. Approval of members was required. Now, they themselves lent £35,000 to the company without obtaining the approval of the members in the general meeting, can they claim the entire amount from the company? No, you are directors. You yourself are a party to the transaction. How come you can say, I didn't know that the company needs the approval of the members if it is borrowing beyond 10,000? You are the director. How come you are not aware? You will not get the benefit of indoor management. Acha, you are suspicious. You should have inquired. If you would have inquired, you would have come to know that the company, in this case, is not allowed to enter into the transaction. You behave negligently, and we cannot reward those who behave negligently. Now, let's say, for example, that I am a director in two companies, company A and company B. Now, you are a creditor of company B. I give you a check. I, director, has signed, but the check is of company A. Now, you are a creditor. Will you accept this check? Of course, you will have some doubt in your mind that I am a creditor of company B. Why is company A's director giving me money? If you were doubtful, you should have inquired that whether the company is even authorized to do that. You did not inquire. You cannot get the benefit of indoor management. You behave negligently. Forgery, yes, the company cannot be held liable. Highlight this: the company cannot be held liable for forgery committed by officers. See, we are giving you benefit for irregularity in the procedure. Forgery is illegality. You cannot get any benefit in case of illegality. The company cannot be held liable for forgery committed by officers. Then who will be held liable? The officers themselves. Copies of the memorandum articles can be obtained within 7 days of request, can be asked as MCQ. Conversion of companies already registered. This is not providing a very detailed procedure. Here, conversion is a very basic kind of conversion procedure. So if I want to convert my private company to public, public to private, I want to convert OPC into private company or a public company. So what is the procedure? You need to convert, you need to first alter your memorandum and articles of association. See, in the memorandum, I will have to change the name clause. In articles, I will have to remove those restrictions. I may also have to change certain provisions which are very peculiar to that kind of company. So yes, a lot of alteration may be required in the memorandum and articles. Of course, we will also have to increase the number of members. If you are converting from private to public, we may have to increase the number of directors. If you're converting from public to private, you may have to reduce the number of members. So these changes are required to be made. First step is, so this is step number 1. No, this was step number 1. Alteration of articles. Then you will also file an application to the registrar, who will, after satisfying himself, close the previous registration, and then they will give you a new certificate of incorporation with the new name. Of course, you are altering from one company to the other, name will be altered, and registration will not affect, it will not affect debts, liabilities, obligations of the companies which that were present before change. See, just because you have converted doesn't mean that the identity of the company has changed. Only the form has changed. From private you're going to public, public you're going to private. So the debts, liabilities which were incurred in the earlier name, in the earlier registration, will continue as if the conversion never took place. Very important for exam. Can a subsidiary become a member of the holding company? How can you control the controller? Void hai, ye void hai. Section 19, the section number is also very important. So a subsidiary cannot become a member of the holding company. But I was a member, okay, I was holding 5% in the holding company even before I became a subsidiary. Then in that case, I can continue to remain the member. I will get to exercise all the rights of a member except voting rights. Okay, I will get to enjoy all the rights except voting. Do I need to surrender these shares? No. You can continue. You were a holder even before you became a subsidiary. You can continue. You will get to enjoy all the rights of a member except voting rights. Okay. If the subsidiary is holding shares as a legal representative of the deceased, or it is holding shares as a trustee, has it become the owner? Is the subsidiary holding as an owner? No, you're only holding in the capacity of legal representative or trustee. You are not the owner. This is allowed. You can even go attend the meeting, vote, but in the capacity of a legal representative or a trustee. This entire part is important, okay? You need to memorize this. Service of document can be asked as a theory question. How can we serve documents on the company? See, we need to communicate with the company. So where can we send those documents? At the registered office of the company. How can we send those documents? Either by registered post, speed post, courier, hand delivery, or electronic mode like email. So if you want to communicate with the company, there are various modes which are specified. I want to communicate with the registrar, so submit the document at his registered office. How? What is the procedure? You can send by regular post, registered post, speed post, deliver, hand deliver, or by electronic mode like email. If I want to communicate with the members of the company, okay, members, then you can send the document by regular post, registered post, speed post, courier, hand delivery, electronic mode. But the member has requested, this is very important for case-based questions. Now, the member complains that he doesn't receive the notices on time because the postman doesn't deliver the notices to him. So he is ready to pay some extra money and asks for the documents, notices to be sent by courier only. So we took 500 rupees from him. And this predetermined fees, this will be mentioned in the annual general meeting. So we took 500 rupees from him. Now in this case, the company is bound to send the notice by that particular mode only because he has paid money. But in spite of that, if we send by regular post or speed post, then he can challenge the resolutions which were passed at the meeting. He can challenge the validity of those resolutions. In case of joint holders, the notice will be sent to the person named first. And if it is sent to that person, we will assume that everybody has received the notice or the document. In case of death or insolvency, it will be sent to the official receiver, assignee. This we will cover later, okay? Now, authentication. Who can sign the document? The company is an artificial person, but it is a person nevertheless. So company is authorized to contract. The company can enter into contracts. It can buy property. It can buy assets. But who will sign those documents? Company is an artificial person. It will be authenticated by the key managerial personnel as discussed under section 2 clause 51, as defined under section 2 clause 51, or any officer or employee duly authorized by the board. So how will the board authorize? How will the board authorize? See, in this case, if the company has a common seal, so what the company will do, on a document, they will affix the common seal and they will authorize the person under this seal to sign the documents on his behalf. So what about the deeds, documents, etc.? So if a company has a common seal, then a company may, by writing under its common seal, authorize any person either generally or in respect of specific matters as its attorney. It means someone who is authorized to enter into contracts on behalf of the company. So we will affix the common seal. We will write the name of the person who is authorized either generally. You can enter into any contract or you can enter only into specific contracts. If the company does not have a common seal, then on that document, either 2 directors will sign or 1 director and 1 company secretary will sign, and they will authorize a person who will sign the documents, who will authenticate the documents, who will enter into contracts and bind the company. What about bills of exchange, hundis, promissory note? If the authorized person is either drawing, endorsing, accepting, it is as if the company has performed that act. So students, this was section 22, and with this we have also come to an end of this chapter. It was a very quick and a fantastic revision. I hope you agree. Give me a thumbs up. Mention in the comment section that yes ma'am, we are feeling confident. We are now feeling confident about the keywords. We know what kind of questions can be asked on a particular section because I have highlighted whether it can be asked as an MCQ or a case-based question. Students, many case-based questions are mentioned in my compiler. You can visit my website capreetiaggarwal.com for books, compilers, podcasts, full course, detailed lectures. And if you have any query, you can also contact me on my number. It is given on the website. Before leaving, do give me a thumbs up. Mention in the comment section whether you are feeling confident now, whether you are able to understand what is expected in the exam. And also, if you're loving these revision sessions, I'm waiting for your comment. Okay, in my next session I will discuss with you prospectus and allotment, but I feel let me first cover the important chapters. Yes, let us go through the provisions relating to management and administration, because many students have messaged me and they say that ma'am, chapter 7 is very difficult for us. So I will begin with management and administration and I will see you there. But do subscribe to this channel and hit the bell icon and also the thumbs up sign so that you get notifications for all the other videos. Also visit my website once.